Hey, it's James, Fathers Rights and Resources, hashtag how I got custody. Some of you saw this video on TikTok last night. I'm going to have to redo it because TikTok sneaks in music on my videos at the last minute, or I overlook them doing that and I don't ask to put music on videos. Anyway, this is about injunctions. And if you got an emergency restraining order against you and you got blindsided by it, this is something your attorney will never tell you, or almost never tells any guy out there. So this is how to fix that emergency restraining order before you have the hearing that's coming up, called the return hearing or a show cause hearing. So the rule in injunctions are any type of emergency restraining order. If you're a land developer or real estate developer and you see a building that's about to be demolished and you want to buy it, you can go to court and get an injunction to stop the demolition. Or the court might enter an injunction, or somebody might ask for an injunction so that the media won't be allowed in the courtroom in a criminal case or high profile case or something like that. An emergency ex parte restraining order or protection order is a type of injunction. So the rules on injunctions govern it. So what you should do is Google your state. If you're in Massachusetts, Florida, Texas, or whatever, you type in Texas Civil Rules Injunctions or Florida Civil Rules Injunctions. And usually you'll come up with Civil Rule 65. That's the federal court's rule on injunctions. The state courts usually adopt or copy the exact same numbering and rule and civil rules that the federal courts do for federal lawsuits on, civil, lawsuits for violation of your constitutional rights or whatever in federal court. So when you find Civil Rule 65 or whatever the rules are on injunctions, it usually starts off with no injunctions shall be obtained without notice to the other party. That means when she got the emergency restraining order against you, she was supposed to give you notice she was going down there. But there's an exception. The only exception is that giving notice to the other side will cause irreparable or irreparable harm. For example, a woman will go down to the emergency courtroom and say, so just know that the assumption starts that you have a right to be notified. You have a constitutional right under the fundamental fairness doctrine to be notified of a hearing and the right to be heard in any proceeding. Google it, fundamental fairness doctrine. Everybody should know this. That's fundamental to your basic due process rights. In old Europe, they used to have court hearings in some parts of old Europe, they'd have court hearings without telling somebody. They'd find them guilty without letting them know, and they didn't have a chance to be heard. So we changed that. You have a fundamental fairness doctrine right to be heard. So in the rules on injunctions, they have to give you notice. The only exception is the irreparable harm section. So, for example, a woman will go down there and say, hey, I need an emergency restraining order. I can't tell him right now that I'm coming down here or he'll kill me. So they grant an emergency restraining order. You're served. You're getting kicked out of the house. You got to grab some clothes. You got to find a place to stay. Another example of an excuse to not give notice is, let's say you're a guy who's going to get a restraining order because the mother might take off with your kid. And you say, hey, I can't give her notice that I'm going. I can't give her notice that I'm trying to get this restraining order, because if I was to tell her last night that I'm coming down to the restraining order or the ex parte courtroom, if I told her that ahead of time or before I come down here, she'll be on the next red eye, or she would have been on the next red eye last night, or on a flight or drive, out of state, and she's got a timeshare in Florida or in Cuba or in Mexico, and I'd never see the kids again. I need you to order that she can't take the children out of state, because if I give her notice and tip her off and tell her, that will cause the irreparable harm of her taking flight. Or a lot of women will say, if I give him notice that I'm coming down to ex parte, he'll kill me. And that would be irreparable damage or harm. So giving notice of an emergency ex parte restraining order hearing Giving notice always has to happen unless you can prove irreparable harm. And the rule says that it must be shown by affidavit. So somebody's got to swear under oath what the irreparable harm is. And you should read the mother's petition or request for a protection order and see the section. Usually there's a section that says, what notice did you give the other side, if any? And if you didn't, what's the irreparable harm? Now, that excuse about, oh, he'll kill me or whatever, that's stupid, because if her going to court will piss a guy off to the point where he'll kill her and risk the death penalty, how is, if she wins the restraining order, he'll be even more pissed. And how is a piece of paper going to stop him from risking the death penalty? He's already crazy enough to do that. That whole thing is insane. And people should point that out to the court. But nobody ever does, because everybody's afraid what the judge might think, or what somebody might say, or how it looks. So nobody ever challenges all the stupidity in the court system, so the court system stays stupid. And then you guys turn around, or everybody else turns around and says, well, how come nobody's doing anything about this system? Because nobody challenges stuff every time they have a chance to challenge it, because everybody's a punk-ass little coward. So there's an example of how to fix the system, things that are wrong with the system. I mean, that's one of the pieces of leverage that women get, is an emergency motion that sets the ball rolling on a case and kind of gets the momentum going, or the snowball going. But nobody ever challenges it when they have a chance to, so it never changes. But in the very rules on injunctions, you'll see later on down in the rules that you have a chance to dissolve or quash the rule, or quash the emergency order. But you have to give the other side 2 days notice or 3 days notice, depending on which rule says that. So, or what the rule is in your state. Usually you have to give 2 days notice. So, for example, let's say it's May 1st on Monday, and I get served with an emergency restraining order Monday night. The mom went to court, got an emergency restraining order. I got served later that night. I got blindsided. I can file a motion to dissolve or modify or amend that order or quash it by going to the courthouse and setting up a hearing in a couple days, and I got to give the mother a couple days notice. So she gets notice. You don't get notice, but she does. It's kind of crazy. So let's say I don't get my stuff together. It's Monday. I don't get my stuff together till Wednesday. Then we have a hearing on Friday. Now the return hearing, or the show cause hearing from the emergency order, they get an emergency order. Then they set up a full hearing where you have your due process right and your chance to be heard and argue and defend yourself. That's called a return hearing, because you return to court. Or a show cause hearing, where you have to go to court and show good reason or good cause why she shouldn't get the relief. It should just be called, full hearing, or just leave it at the return hearing. It's a show cause hearing to show cause why the relief shouldn't be granted for the other side. Is kind of backwards language. Anyway, so May 1st she gets a restraining order. There's not I don't get my show cause or return hearing a chance to defend myself till like May 20th. I want to hurry up and go to court and quash that, or dissolve it, or at least modify it so I can have access to the kids and say, look, I care less whether I talk to the mother ever again. I just want to be an involved father. And we can meet at a police station or third party. She says that I'm not dangerous to the kids, or whatever the argument is, and get that part quashed or fixed. I've had all kinds of guys get stuff quashed or fixed or modified or totally terminated at a motion to quash hearing that they set up. And even if a guy doesn't win anything, or win all of it, or maybe only gets a partial victory at the quash hearing, that's at least a temporary, or that's at least a practice try or a practice run at it. So now you're even more ready for the return or show cause hearing. You just had a practice run at it. There's no, even if you lose, you're still back at square one. At least you got some experience under your belt. But see, did any of your attorneys tell you that? Any of you guys out there with an emergency restraining order, your attorney tell you, we could do this motion to quash, or motion to dissolve, or try and modify the order. You want me to try that? They don't even think about telling you that. That's why I'm sitting here telling you something for free that your attorney isn't even telling you. You spend $10,000 on your attorney, and people get pissed at me that I charge any money when they do one-on-one consultations. Now I have a defense against restraining order packet that has a sample motion to quash in it too for $45, and countless guys have gotten that and totally got rid of a restraining order. So anyway, check it out.